Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Jonathon Kappy.
And I'm Mark Lahn.
Welcome to Hull on Estates. You're listening to episode number 725. And today we are going to be discussing a topic that doesn't come up often in the context of estates and estates litigation, but it comes up often enough that you should at least know and be able to recognize certain issues. And I think what we're talking about today is relief from forfeiture. Okay. And relief from forfeiture is something that comes up in relation to most often mortgages, and they can be punitive. And it allows a court to relieve a defaulting party from certain provisions that get triggered from mortgages or other types of security under different circumstances. And so today, I think there's a couple of different tests that the courts have applied. The Court of Appeal more recently in 2017 has applied one in particular, and we're going to go through that. But we want to help our listeners and our viewers identify these issues so they can turn the mind to them if they come up. All right. And this all starts with Section 98 of the Courts of Justice Act. Okay. And the Courts of Justice Act states, a court may grant relief against penalties and forfeitures on such terms as to compensation or otherwise as are considered just. Now, I practiced corporate commercial law for about 10, 12 years before I got into estates law. And now I've done estates law for a little bit longer than that. And in the course of settlement negotiations, these kind of things often come up. Mortgages, security for payments. One party promises to pay another. They can't pay it right as a lump sum in cash up front. It gets spread over time. And then the recipient of this money who's waiting wants security. And oftentimes a mortgage on a property, if we're dealing with an estate, perhaps one party is buying out another party and keeping the house. Collateral can be given in the form of a mortgage on the estate property to ensure that those payments are made. Now, the terms of this mortgage and the terms of the security can be endless. I mean, as creative as you want to be. Some of them are fair. Or more reasonable as you would think of them when you're borrowing from a bank. You know, you have to pay X amount per month plus a certain amount of interest that's agreed upon. If there are defaults, then there's a curative period in which you can fix your default. There may be additional penalties that need to be paid. But sometimes they can go way overboard, and I've seen them go way overboard. I'll make up a fictional example. But let's say someone is spreading a $200,000 payment over, 2 years or 3 years, whatever it is. $1 million property is given as collateral. But the terms of this settlement are that if there is a single breach of any of the payments, the day following that first default, the entire property is forfeited to the other person. Whether there's $200,000 remaining to be paid, whether there's $200 remaining to be paid, that $1 million property is forfeited as a penalty for the missed payment. All right. And so that is perhaps an extreme example, but those are the types of things that can be negotiated in the context of a settlement if a person is desperate enough to keep the property and can't pay for it and is roped into agreeing to clauses they think they're not going to breach. And so like, oh, well, I'll never miss a payment. Don't worry about it. And then you get hit by a car on the way to the bank and you're in default. And now these penalties kick in. So this is sort of where we get into relief from forfeiture. So Mark, why don't you take us through, some of the tests and the considerations the court will look to when the court is deciding whether or not it is going to relieve this defaulting party from the forfeiture that they've previously agreed to.
Yeah, absolutely. So there's kind of two legal tests that have emerged in the context of relief from forfeiture. The courts haven't really taken a definitive stance as far as which test applies in which circumstances. So you may find that the elements in one test kind of fit into the facts in front of you a little bit better than the other. The second test that I'll get into has been applied more consistently in deposit cases, so forfeiting a deposit paid. So it's likely that that test will be applied in those circumstances. But the first of the two tests is this, it's referred to as the Saskatchewan River Bungalows test, and we'll have the two citations for these tests in the podcast description. And this test looks, it takes a four-factor analysis. So the first factor is the conduct of the party seeking relief. The second factor is the gravity of the breach of contract. The third factor is whether the right of forfeiture was intended to secure the payment of money. And then the fourth factor is whether there was a substantial disparity between the value of the property forfeited and damage caused by the breach. And no single factor here is determinative. It's all in a contextual basis. And whether you're looking at either one of these tests, the starting point is really, this is an equitable remedy. The courts have made it very clear it's to be granted sparingly. This isn't something, a power that a judge wants to exercise regularly. And there's a lot of policy considerations surrounding that. I mean, you think about wanting to encourage settlement, and if the idea is, I can settle, but I really don't have to conform strictly to the terms of the minutes of settlement or whatever the settlement agreement is, that's a real problem, and it kind of undermines the sanctity of settlements. So
holding parties to their bargains, right?
Exactly. So that's the kind of thing where the court is kind of looking in Saskatchewan River Bungalows, which is the test that you'll kind of more commonly see in these cases. They're just sort of trying to look at the totality of the circumstances and figure out, is it really going to be inequitable to hold the parties to this bargain? Like, if the idea behind the settlement is really just to secure the payment of a fixed amount of sum, and there's some, maybe there's a delay in getting a mortgage, or like you said, Jonathan, some, a day late on a payment, does it make sense when the party can really easily cure that defect to have them forfeit the property? So those are the kind of things that the court will look at in Saskatchewan Rivers. The second test originated in a case called Stockloser and Johnson, but was more recently applied by the Court of Appeal in 2017. This is just a two-part test. The first part is the sum forfeited must be out of proportion to the damage, and the second part of the test, it must be unconscionable for the seller to retain the money. So it's a little bit simpler to proceed under this test. The idea of something being unconscionable is obviously a kind of a higher bar to meet, and there's case law behind exactly what the court will find to be unconscionable. But those are kind of the two tests that have emerged in these cases, and that's how the court will consider it.
Yeah, so this is kind of a difficult thing to plan for, right? Because really what we're talking about is the circumstances where the parties reach a bargain, and the court's going to say, you know what, I'm not going to hold one of the parties to their bargain, either because it's unconscionable or because a substantial disparity between the value of the property being forfeited and the damage caused or things like that. So it's tough to plan for, because it's basically say you're going to, and perhaps a court is not going to hold these parties to their bargains for certain reasons. And so, but that doesn't mean we can't be aware of these tests and aware of the power that the court has to give relief from forfeiture if certain circumstances arise. And so from that perspective, it's not a bad idea to keep those in mind as you're drafting settlement documents, as you're drafting any contract where there may be a huge disparity between a penalty and the actual damages that a default causes. And so you did a great blog about this earlier this month. I just want to make sure all of our viewers know that they can go to the Hull and Hull webpage and find your blog and give it a review. But you do list some examples of things that the parties can keep in mind as they're drafting settlement. So why don't you sort of highlight those for us?
Yeah, so like you said, Jonathan, I don't think there's any clear tool that lawyers and settlements can use to completely avoid relief from forfeiture. It's quite clear this is an equitable remedy. If a judge feels it's appropriate, it may be applied, even though it is used sparingly. But I think there's a few things that you can do. Like you said, be careful about the drafting and what are the intentions behind the forfeiture provisions? If it's so a payment is missed or a mortgage isn't secured and the property is sold, is that just to secure the payment of the settlement amount, or did the parties carefully consider that and think, no, I'm actually want to bargain for more if that happens? And that could be for a variety of reasons, the lost opportunity in having those funds, or the delays that will come with the sale. They're going to expect maybe more in return. So if that's the party's intention, we could put that right in the settlement documentation. You could specifically say that the parties acknowledge that relief from forfeiture is available and are waiving that right. I think anything on the drafting side that can kind of improve the equities on one side helps. So if we're putting in kind of graduated penalties, or if you miss a payment by this amount, you have this kind of grace period. I think all of those sort of drafting considerations kind of help, and it'll be more difficult for the other side to seek relief from forfeiture, where there's basically so many opportunities that they've had to cure the conduct, and they haven't been able to do that. And so obviously, whichever side you're on of the dispute will sort of inform what approach you want to take. If you want to give your client more flexibility in missing payments, you maybe won't recommend some of these remedies. If you're on for the estate or the person that wants that money without the threat of relief from forfeiture kind of looming in the air, then you'll want to talk about some of these provisions to add in the agreement.
Yeah, I mean, listen, I think that it's, at the end of the day, it's important to document what the actual agreement is. If the parties agree that there's going to be a punitive provision in there, if they properly document, it's harder to argue that it's unconscionable, right? So, everyone has to be aware of it. It has to be, you can't sweep it under the rug and just stumble upon it, and if that's the real bargain, I would hope that the courts will, short of this example, if I was going to the bank to pay the bill and I got hit by a car and I missed it by a day, kind of thing, it is not going to spare them. So I would have to believe that there really have to be extraordinary circumstances in order for a court to give this relief for forfeiture.
Absolutely.
So I think that concludes our podcast for today. Until next time, we want to thank you for listening. I'm Jonathon Kappy.
And I'm Mark Lahn.
Should you have any questions, please email us at info@hollandhall.com or contact us through the contact page on our website. Have a great day.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.